Good morning, everybody. Protocol has been established. I will observe the protocol, but first of all, I would just like to greet my brother, Chief Justice Raymond Zondo, who is our host today, and the Deputy Chief Justice Maya, who is also our host today. My function here today is just to give you the background as to the purpose of this gathering. Today, well, before I do that, my name, as the program director has indicated, my name is Raymond Zondo from Supreme Court of Appeal. Thank you, Program Director. Today, the South African Judiciary will present its 5th annual report for the 2022-23 financial year. We hosted our first Judiciary Day in November 2018 to present our performance report for the 2017-2018 financial year. The decision to present an annual judiciary report was guided by the principle that judicial independence is inextricably linked to judicial accountability, thus requiring us to account directly to the nation on the responsibilities we have been entrusted with. The Constitution of the Republic of South Africa provides that the judiciary is independent and subject only to the Constitution and the law. The Constitution further provides that the Chief Justice is the head of the judiciary and exercises responsibility over the establishment and monitoring of the norms and standards for the exercise of judicial functions of all courts. These norms and standards, ladies and gentlemen, seek to enhance access to quality justice for all, affirm the dignity of all users of the court system, and ensure the effective, efficient, and expeditious adjudication and resolution of all disputes through the courts where applicable. Ladies and gentlemen, in keeping with the constitutional principles of accountability and transparency, this annual judiciary report provides the public with information on the performance of the judicial function by the judiciary in order to ensure transparency and underscore the judiciary's commitment to account to the public. The purpose of the Judiciary Day and the annual judicial report, therefore, is to explain to the nation how we have served them in the recent past, what challenges we confront, and how we seek to address them, barring those that are incapable of being resolved only by the judiciary without meaningful intervention by other arms of the state or the cooperation of other institutions within the broader judicial system. The annual judicial report that the Honorable Chief Justice Zondo will present today provides an overview of the performance of the courts. Distinguished guests, I take this opportunity to remind our stakeholders present today that this is an interactive session. I wish to express, on behalf of the judiciary, our most sincere wish that the engagements from the interactive session to be facilitated by Judge President C.M. Musi will positively contribute to enhancing the independence, impartiality, dignity, accessibility, and effectiveness of the courts. In conclusion, ladies and gentlemen, The hosting of the Judiciary Day accentuates the judiciary's commitment to maintaining the public's trust and confidence. That commitment is foundational in a democratic system based on a separation of powers among co-equal arms of state. We trust that our 2022-23 annual judiciary report will be well received by the South African public. Thank you for listening.
I just want to correct one small issue that I should have dealt with. When I invited the Deputy Chief Justice, I should also have referred to her as Bungane Mahadebe. And when I invited Deputy President Zondi, I should have said Nondaba. I now take the opportunity to invite the Chief Justice of the Republic of South Africa, Raymond Mlungisi Zondo Sohlaza. Thank you.
Thank you very much, Program Director, Judge President Dunstan Mlambo, and I'm going to retaliate and say Mapisa. Before I begin, I think I should highlight, even before I begin my address, the fact that we have a new Minister of Justice and Constitutional Development after the elections, Minister Simelane, and we have a new Deputy Minister of Justice and Constitutional Development, Deputy Minister Andres Nel. And I thought that I must just particularly welcome them before we go further. But I thought also, before I go further, I must take this opportunity to congratulate Justice Mandisa Maya, our Deputy Chief Justice, on her appointment as Chief Justice of the Republic of South Africa with effect from 1 September 2024. I think all of us know how historic this appointment is. And I thought that before I start, I should express my congratulations and also express my appreciation for the support that she has given me over the past 2 years since her appointment as Deputy Chief Justice. And of course, now she is Chief Justice Designate. Chief Justice Designate, Justice Mandisa Maya, Justices of the Constitutional Court, President of the Supreme Court of Appeal, Justice Molemela, and all justices of the Supreme Court of Appeal, Judges President, Deputy Judges President and Judges, Regional Court President, Chief Magistrates and Senior Magistrates present, and all other members of the judiciary present here today, and all those who are following these proceedings online. Honorable Minister of Justice and Constitutional Development, Minister Simelane, Honorable Deputy Minister of Justice and Constitutional Development, Deputy Minister Andrew Snell, Honorable Ola Ngola, Chairperson of the Portfolio Committee on Justice and Constitutional Development, and other members of the Portfolio Committee who are with us today. Commissioners of the Judicial Service Commission present, members of the Council of the South African Judicial Education Institute present, Advocate Shamila Batoi, National Director of Public Prosecutions, members of the Audit and Risk Committee, members of the Legal Fraternity, Ms. Sejosengwe, Secretary General of the Office of the Chief Justice, and all OCGO officials present here today and joining us online, heads and representatives of the national departments, state institutions, and members of the National Efficiency Enhancement Committee, members of the media present here, members of the public who are following these proceedings virtually, ladies and gentlemen, it gives me great pleasure, and I regard it as a special honor and privilege to stand before you today in order to present the judiciary's annual report in respect of the year 2022 to 2023. Judiciary Day is an important annual occasion on the calendar of the South African judiciary. It is on Judiciary Day that through the Chief Justice as the head of the judiciary of South Africa accounts to the people of South Africa for the performance of their functions. Section 55(2)A and B of the Constitution places an obligation on the National Assembly to provide for mechanisms to ensure that all executive organs of state in the national sphere of government are accountable to it and to maintain oversight of the exercise of national executive authority, including the implementation of legislation, and also to maintain oversight of any organ of state. Section 92 of the Constitution deals with the accountability and responsiveness of the President and his or her ministers for the exercise of executive functions entrusted to them. Section 92(2) provides that members of the Cabinet, which includes the President but excludes deputy ministers, are accountable collectively and individually to Parliament for the exercise of their power and the performance of their functions. Section 92(3) requires members of the Cabinet to act in accordance with the Constitution and to provide Parliament with full and regular reports concerning matters under their control. Section 93(2) ensures that deputy ministers are also accountable to Parliament for the exercise of their power and the performance of their functions. There are no similar provisions in the Constitution in respect of the accountability of the judiciary to Parliament or the executive in respect of the performance of the judicial functions of the judiciary. This does not mean that the judiciary does not need to account for the performance of its judicial functions. Indeed, we take section 1652, read with subsection 6 of the Constitution, as providing the constitutional basis for Judiciary Day and for our annual judiciary reports through which we account to the public of South Africa for the performance of our judicial functions. Section 1652 of the Constitution provides, and I quote, "The courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear or favor or prejudice." Section 1656 of the Constitution places upon the Chief Justice, as the head of the judiciary, the responsibility for the establishment and monitoring of norms and standards for the exercise of the judicial functions of all courts. In respect of the superior courts, the Chief Justice exercises this responsibility with the assistance and support of the heads of court, which are the President of the Supreme Court of Appeal and the judges president of the various provincial divisions of the High Court and of the specialist superior courts. In respect of the lower courts, the Chief Justice exercises this responsibility with the assistance and support of the judges president of the various provinces, the regional court presidents, the chief magistrates, and other members of the leadership of the regional and district courts. Therefore, the holding of Judiciary Day and the presentation of the 6th Annual Judiciary Report are the results of collaboration and cooperation among various structures within the judiciary and the support from the leadership of the Office of the Chief Justice and other officials at the OCJ. The holding of annual judiciary days and the release to the public of annual judiciary reports constitutes irrefutable evidence that the judiciary unequivocally and unconditionally embraces the notion that it must account for the exercise of its judicial functions. We must account to the public for the performance of our judicial functions. After all, the positions that we hold as members of the judiciary, we hold because the public adopted a constitution which makes provision for us to hold these positions. Indeed, I want to go further and say the public is central to our constitutional democracy. I remember that in 2017, when I was interviewed for the position of Deputy Chief Justice, one of the commissioners of the JSC asked me the question, what is the significance of the first three words in our Constitution. You remember the first three words of our Constitution? Everybody? We the people. The first three words of our Constitution are we the people. So he asked me what the significance was of those three words. My answer was that those three words at the beginning of our Constitution denote the centrality of our people to the constitutional order that was introduced by this Constitution. If I was asked the same question today, I would give the same answer because it is the correct answer. It goes to the centrality of the people. And yet so often, some of the people who are supposed to serve the people, some of the people who hold positions in our constitutional democracy, who are supposed to put the people first in whatever they do not do so. They only remember selectively that the people are central to our constitutional democracy. What is the scope of the performance of judicial functions covered by the annual judiciary report? The scope of the annual judiciary report that I'm presenting today, like its predecessors, covers only the following matters within the judiciary's performance of its judicial functions. A, matters finalized by each superior court assessed against the target fixed in relation to each superior court. B, delivery of reserve judgments against targets set for delivery of reserve judgments. C, the reduction of criminal backlogs. And whereas in the past, or in some of the years, we did not include the lower courts, in this year's report, we do have information on the performance of the lower courts, even though it is not adequate. There is still quite some work to be done for us to get to a point where we are able to report properly, accurately, and adequately on the performance of judicial functions by the lower courts. The first two features of the scope of the report apply to all courts, whereas the last one applies to criminal courts at high court level as well as in the magistrate's court. I will deal later with other features of the assessment of the judiciary's performance of its judicial functions, which do not fall within the scope of the annual judicial report, but which are nevertheless important. For now, it is appropriate to share with you some of the important information in the report concerning the judiciary's performance of its judicial functions. Court performance. The sixth annual judiciary report provides an overall picture on how the superior courts and the lower courts have performed their judicial functions during the period under review. The annual judiciary performance plan indicators for the judiciary as reflected in the annual judiciary report 2021-2022 remain relevant for this reporting period. The AJPP, namely Annual Judiciary Performance Plan, defines and identifies performance indicators and targets for the various courts. The performance indicators and targets are measures that allow for the monitoring of performance on one or more aspects of the overall functions and mandate of the judiciary. Performance of the superior courts. For the period under review, 11 or 13 performance targets were fixed by the judiciary to be achieved. Of these 13 targets that were fixed by the judiciary for their performance, 11 have been achieved. This represents an 85% achievement. Only 2 performance targets were not achieved. Those relate to the percentage of finalized constitutional court cases, which was 55%, in circumstances where the target that had been fixed for this period, as had been the case for the previous years, was 70%. And the percentage to which criminal case backlogs was reduced. The target that the judiciary had fixed for all superior courts in respect of target was that backlogs should be reduced to at least 30%. Taking all the superior courts, we were not able to achieve that target. We were only able to reduce backlog up to the average of 47%, which means that this will have to be work in progress, and hopefully in the next annual report, we will perform better. We are frank with you, the people of South Africa. We tell you where we have not performed the way we should have. We tell you where we have performed well. We think you are entitled to know because you pay our salaries. We do not think you should not know how we perform our duties. And we will not hide our performance from you. All the superior courts fixed targets for matters that they would finalize during the period under review. That is the 2022-2023 financial year. That means the period 1 April 2022 to 31 March 2023. The targets that the superior courts fixed for themselves and what they achieved or failed to achieve are reflected as follows in respect of all the superior courts. The Constitutional Court had fixed 70%, but it only achieved 55%. The Supreme Court of Appeal had fixed in respect of appeals 80%, and it achieved 85%. In respect of applications, the Supreme Court of Appeal had fixed 80%, and it achieved 91%. The Labor Appeal Court, in respect of appeals, had fixed 80%, and it achieved 96%. In respect of applications or petitions for leave to appeal, the Labor Appeal Court had fixed 90%, but it achieved 100%. In respect of criminal matters finalized in all divisions of the High Court had fixed 75%, and they achieved 83%. In respect of civil matters finalized in all divisions of the High Court, the divisions of the High Court had fixed 64%, but they achieved 85%. In respect of matters in the Labor Court had fixed 58% as their target, and they achieved 58%. In respect of matters in the Electoral Court had fixed 90% as their target. They achieved 100%. In respect of matters finalized by the Competition Appeal Court, that court had fixed 85%, but it achieved 88%. The Land Claims Court had fixed 60% as their target. They achieved 72%. It will be seen from this that the overwhelming majority of the superior courts performed excellently. They either reached their targets or exceeded their targets. It will also be noted that although the courts fixed their own targets, generally speaking, they fixed very high targets for themselves. Quite often, it was 70% and above, and they mostly achieved the targets and, in a number of cases, exceeded them. The Constitutional Court did not achieve its target of 70%, but went up to 55%. Previously, it had done better than 55%. And this issue is being investigated to establish exactly why there was such a big drop. But 55% is, of course, not a failure. It's simply not as good a pass as one would have liked. And of course, in the judiciary, a pass is 50 and above, and not 30%. But of course, I may as well take this opportunity to remind everybody that the public is aware of the challenges that the Constitutional Court is facing, because the public continues to be informed of those challenges. The public will be aware that recently the Constitutional Court took the position that in order for it to properly discharge its obligations and perform in an acceptable way, it will be necessary for an amendment to be made to the Constitution so that it is able to dispose of a number of matters without every justice having to take part in every case. Because at the moment, the constitutional requirement that the justices of the Constitutional Court should sit and bank means that if there are 300 new applications that come in, every justice serving at the court at the time should take part in deciding all those 300 cases. Whereas if 300 new applications or petitions arrive at the Supreme Court of Appeal, because the Supreme Court of Appeal does not have the constitutional requirement that they must sit and bank, they are able to sit and dispose of those 300 new applications through panels of 2, which means that 12 panels or so are able to dispose of 300 new applications and share that responsibility among themselves, with the result that one justice will have sat in only a certain number of matters, whereas if those matters are dealt with in the Constitutional Court, every one of the 11 justices of the Constitutional Court has to be involved in those 300 matters, except where there's one reason or another, acceptable reason for them not to participate. So if the Constitutional Court is able, after a constitutional amendment has been made, to sit in panels in terms of disposing of applications, that will make a big difference. That does not necessarily mean that in terms of matters that get heard as appeals, the Constitutional Court would sit in panels. As things stand, we in the Constitutional Court take the view that as far as matters that would be heard are concerned, those matters would still be heard by the full panel. But a lot of other matters, applications would be disposed of without every justice of the Constitutional Court having to be involved. Of course, also, the public will be aware that we addressed the issue of resources in the Constitutional Court, and we have proposed to the executive that experienced lawyers be employed who would provide support to the justices of the Constitutional Court and therefore make their load lighter. We are going to wait to hear from the executive whether they go along with the idea of a constitutional amendment as well as giving us more resources. We have looked at many apex courts internationally and found that a lot of them get assistance from experienced lawyers in order for the justices of the apex courts to perform their duties properly. It will also have been seen above that there must be a lot of room for improvement in the performance of the labor court. It set for itself a low target of 58% and achieved it. It needs more posts for judges in order to cope with its workload. Indeed, it's been a few years that the labor court has approached the executive to ask for more posts of judges to be created, to ask for more courtrooms so that more cases can be done. I have been involved in that. That has not been coming as quickly as it should have. There is nothing judges can do if there are not enough judges and if there are not enough courtrooms. And in order for judges to have that, they depend on the executive. As I say, this is a matter which has been discussed with the executive, and they are the ones who must make decisions concerning the creation of more posts for judges. A reduction of criminal case backlogs. With regard to the reduction of criminal case backlogs, the various divisions of the High Court had fixed 30% as their target, to which they would reduce the backlog. However, collectively, they have failed to achieve this target and managed to only reduce the criminal case backlog to 47%. Here, they did not do well. On reserve judgments, as far as reserve judgments are concerned, collectively, the superior courts had fixed 70% as their target for the handing down of judgments that have been reserved during the period under review. They succeeded in handing down 72% of the judgments reserved during the period under review, thus doing very well and exceeding their target by 2%. During the period under review, the Supreme Court of Appeal completed 204 appeals out of a total of 239 appeals. This was 85% of the appeals. The SCA achieved 5% more than the target of 80% it had set for itself. The Supreme Court of Appeal finalized 1,266 applications or petitions out of a total caseload of 1,387 applications or petitions. This was a 91% achievement. This means that the SCA exceeded its set target of 80% by 11%. Compared to the previous year, the SCA managed to exceed the set target of 80% during both reporting periods by finalizing 1,266 applications and petitions, respectively. Specialized courts overview. During the period under review, the Labor Appeal Court finalized 24 appeals out of a total caseload of 25 appeals. This is an achievement of 96%. The LAC exceeded the annual target of 80% by 16%. The Labor Appeal Court also completed 126 petitions out of a total caseload of 126 petitions. This was 100% performance. This means that it exceeded its target of 90% by 10%. The Labor Court completed 2,034 matters out of a total of 3,512. This represents a 58% achievement. This means that it achieved the set annual target of 58%. It also represents a decline of 18% to its performance recorded for the previous reporting period. This period under review, 18% less Labor Court matters were received, whilst 21% less matters were finalized. The Labor Court sits mainly in 4 locations: Durban, Gqeberha, Cape Town, and Johannesburg. The caseload decreased in 3 centers, save for Durban, which increased by 7%. Matters finalized in the various Labor Court centers have decreased, particularly by 34% in Cape Town, 30% in Gqeberha, and 31% in Johannesburg. The Land Claims Court completed 144 matters out of a total of 199 matters. This represents a 72% target performance. This is an overachievement of 12% against the set annual target of 60% and an impressive improvement from the previous financial year. The Electoral Court only had 11 matters and it finalized all 11 of them. This represents 100% performance which is an overachievement of 10% against the set annual target of 90%. The Competition Appeal Court finalized 15 matters out of a total of 17 matters. This represents 88% achievement. It represents an overachievement of 3% against the set annual target of 85%. The percentage of criminal case backlogs. The judiciary is committed to the reduction and ultimately elimination of backlogs in the various courts. The percentage to which criminal case backlogs reduced refers to the percentage to which it was intended to reduce the case backlogs during the period under review, and the percentage to which the case backlog was actually reduced. The annual target for all superior courts is set on 30% and mainly aims to ensure the finalization of criminal matters within 12 months from the date of the accused's first appearance in the High Court. At the end of the period under review, the total number of outstanding criminal matters in the various divisions of the High Court was 970, whereas the total number of backlog cases was 460, which represented a backlog of 47%. The performance during the reporting period, therefore, is an underachievement of 17% against the set target of 30%. Compared to the previous reporting period, the number of outstanding criminal trials increased to 19% compared to the 870 outstanding trials and 28% in the criminal case backlogs compared to the 353 reported criminal case backlog. The reason for this is ascribed to logistical challenges, mainly due to the continuous load shedding, which has stopped temporarily, which had an adverse impact on the operations of the courts. Compared to the previous reporting period, the number of outstanding criminal cases increased by 19% compared to the 917 outstanding cases and 2% in the number of criminal case backlogs compared to the 453 reported criminal case backlogs. This increase is also ascribed to logistical challenges, mainly due to the continuous load shedding, which had an adverse effect. It should be noted that in order to successfully attain the indicator on backlogs, the percentage of backlogs should be less than the annual target of 30%. The target was achieved in the Eastern Cape Local Division, in Bisho, Free State Division, Bloemfontein, Gauteng Local Division, Johannesburg, Gauteng Division, Johannesburg, Limpopo Division, Polokwane, and the Limpopo Division of the High Court. During the period under review, the various divisions of the High Court managed to finalize 9,715 criminal matters out of a total of 11,765 criminal matters, which represents 83%. The annual target of 75% was exceeded by 8%. Compared to the previous reporting period, a marginal increase of 6% is noted in the total number of criminal matters, 11,765, compared to the 11,098 reported during the previous year, whilst a decrease of 1% is noted in the total number of criminal matters finalized. From the above national overview, it is evident that the majority of the divisions of the High Court managed to achieve the set annual target of 75%, with the exception of the Eastern Cape Local Division, Mthatha, Eastern Cape Local Division, Gqeberha, Gauteng Division, Pretoria, Gauteng Local Division, Johannesburg, Gauteng Division, KwaZulu-Natal Local Division, Durban, Limpopo Local Division, Thohoyandou, Mpumalanga Division, Mbombela, Mpumalanga Local Division, Middelburg, Mpumalanga Division, Middleburg, and Northern Cape Division in Kimberley. The reason for this underperformance is ascribed again to logistical challenges and load shedding. The highest percentage was achieved by the Free State Division, Bloemfontein, 94%, and the Limpopo Division, Polokwane, 94%, followed by the Western Cape Division, Cape Town, 92%. The Gauteng Division achieved 57% performance, which represents 18% below the target of 75, and can mainly be ascribed to the complex nature of the cases that the courts have to deal with, coupled with the multiple accused persons involved in many of the cases. Percentage of civil matters finalized in all divisions of the High Courts. During the period under review, a total of 94,347 civil cases were finalized out of a total of 110,387 cases. This represents an 85% performance against the set annual target of 64%. This means that the target was exceeded by 21%. During the period under review, all divisions of the High Court achieved or exceeded the set annual target of 64%. Compared to the previous reporting period, a decrease of 9%, represented by 9,884 cases. Performance is noted in the total civil matters finalized. High percentages were maintained by all divisions of the High Court, with the Limpopo Local Division, Toando, achieving the highest percentage of 98%, followed by the Gauteng Local Division, Johannesburg, which achieved 94%. The Mpumalanga Division, Mbombela, 92%, and the Limpopo Division, 90%. Reserve judgments. During the period under review, a total of 3,853 reserve judgments was delivered within 3 months from the date on which they were reserved. This was out of a total of 5,368 judgments delivered, which represents an achievement of 72%. The target of 70% was therefore exceeded by 2%. Compared to the previous year, the total number of reserve judgments delivered decreased by 3%, while the number of reserve judgments delivered within 3 months also decreased by 3%. The highest percentage in delivery of reserve judgments within 3 months is recorded in the Limpopo Division of the High Court, Polokwane, while the Constitutional Court achieved 18% in the delivery of reserve judgments within 3 months. As I've explained in the public before, the Constitutional Court delivered some of its judgments within 3 months and others after that. Indeed, it delivers some of its judgment after 6 months and sometimes even 8 months. This performance on the part of the Constitutional Court, I've said before, needs to be considered in the context of the manner in which the Constitutional Court operates. As I said last year, on this occasion again, when 11 judges sit to decide one matter, it's not going to be as easy as when one judge decides that matter. It's not going to be as easy as when 3 judges decide that matter. And indeed, it's not going to be as easy as when 5 judges decide that matter, because all of them must apply their minds and take a view. And all 11 must take a view. And also, they mustn't rush to giving judgments, because that might lead to a situation where there are too many dissenting judgments. They need to continue to try and persuade one another with a view that when the discussions are completed, they are able, if possible, to produce one unanimous judgment, or if there are two, there's a dissenting judgment, at least 2 or 3. But once they start producing 5 judgments in a matter, it becomes a difficulty. So there is an obligation on all the justices of the Constitutional Court, when they consider a matter and there are different views, to spend some time to try and find each other before judgment can be handed down. And when there are dissenting judgments, to try and see where the opinions differ and what it is that can be cut out. So it does take some time, but the support that we have said needs to be given in terms of human resources will go a long way, as well as the panels that we suggest should be allowed in terms of the Constitution. The regional courts, for the period under review, the regional courts utilized a combined total of 64,991 court days, a combined total of 189,164 court hours, a total of 37,280 new cases were registered, a total of 41,149 cases were disposed of by the regional courts. Let me mention that the manner in which the performance of the regional courts and district courts has been done up to now, is different from the manner in which the performance of the superior courts has been done. The district court and regional courts tend to look at the hours that the judicial officers spend in court, whereas in the superior courts, we don't look at that. We look at the outcome. How many cases have been finalized within a certain period? And that is mainly because, as far as the superior court is concerned, we all accept that we do not work from 8 to 5. Judges work all the time. They work in the night, they work over weekends, they don't work from 8 to 5. That does not mean that judicial officers in the regional courts and district courts do not work after hours and over weekends. I have no doubt that many do. But that just emphasizes why it's not necessary to be talking about how many hours we have spent in court. We must look at the outcome and acknowledge that judicial officers are not admin staff who come in at 8 and leave at 4, and then they will see work only the following day. They work beyond normal hours. The performance of the regional court divisions can be summarized as follows. Average court hours, 2 hours 54 minutes. This is below the set norm and standard of 4 hours 30 minutes, but the combined hours for both criminal and civil matters adds up to 4 hours 42 minutes. Average clearance rate, 110%. Though most courts are able to keep up with incoming new cases, this is not the position in all regional courts, which indicates that additional courts are needed to deal with the increase in the workload. Finalized cases per day, 0.29. Cases disposed of per day, 0.63. Cases enrolled per day, 2.46. And cases in the regional courts seem to take much longer to finalize, which may be indicative of the increasing complexity of cases in the regional courts. A comparison between the current financial year and the previous financial year indicates that the court days increased by 2%. New cases decreased by 7% that were disposed of, or cases that were disposed of decreased by 5%, and the court hours increased by 10%. Regional Court Civil Performance Overview. For the period under review, the regional courts utilized a combined total of 13,477 court days and combined total of 27,252 court hours and 21 minutes. In respect of civil matters, the performance of the regional court divisions can be summarized as follows. Average court hours, 2 hours, 1. This is below the set norm and standard of 4 hours, 30 minutes. It should be noted that many regional courts are doing both criminal and civil cases on a daily or weekly basis, with only a few regional courts doing civil cases only. Finalized civil applications per day, 1,09. Finalized civil trials per day, 3.6. A comparison of the current financial year with the previous financial year indicates that the court days increased by 14%, enrolled cases increased by 13%, finalized cases increased by 12%, and the court hours increased by 13%. Case flow blockages and challenges. A number of factors contribute towards case flow blockages, which entails the unavailability of stakeholders, the unavailability of courtrooms, defective court recording equipment and intermediary systems, load shedding, natural disasters, and bad and adverse weather conditions, among others. As far as reserved judgments and regional courts are concerned, regional courts do not reserve judgments for longer than 3 months. District courts, the collection and collation of the performance information of the magistrates' courts relies on the integrated case management system for the Department of Justice and Constitutional Development. On 15 August 2023, the heads of the administrative regions of the district courts resolved that as a result, inter alia of the ongoing challenges in the Department of Justice and Constitutional Development, the statistical information for criminal matters would be extracted from the magistrate's monthly judicial return submission. It highlighted that this statistical information is not a proper reflection of the judicial performance indicators for district courts based on the norms and standards. The Department of Justice and Constitutional Development disclaimed the data provided for domestic violence and harassment applications, as well as children's courts matters in their report dated 17 August 2023. They cite a variety of challenges which have given rise to the total number of cases and applications not being captured on the system, and that relates to the incompleteness of the statistics provided. The performance information in relation to child justice, preliminary inquiries, and maintenance matters is released as the completeness of the data is within the purview of the departmental annual performance plan. Indicators and readiness for audit by the Auditor General is established. The department received an unqualified audit and a performance of 80% for the 2022-2023 performance cycle. Average criminal cases finalized, 55%, that's in the district courts. Average child justice preliminary inquiries finalized within 30 days, 84%. Average percentage of maintenance matters finalized within a 90-day period, 89%. The Department of Justice and Constitutional Development is committed to rolling out fiber connections to all the costs to ensure stability on the ICT systems, and has indicated that there are plans to improve on a fresh new data capturing tool where the district court judiciary will be consulted. There is an improvement plan commitment to ensure that all statistics from 1 April 2023 to the current dates are complete and maintained thereafter through an initiative that will see supervisors and data capturers effect the days capturing before the end of each day. The high dependency on stakeholders within court environment has a negative impact on efficient case flow management. The respective district efficiency and enhancement committees and their provincial efficiency enhancement committees are the case flow structures that strive to improve stakeholder relations to address the blockages in the system to enhance court efficiency. And SAJE, in the period under review, the South African Judicial Education Institute conducted 136 courses, exceeding the planned target of 110. This success is attributed mainly to the technological innovation in virtual platforms. SAJE is the statutory institution that is mandated to provide training to those who are not yet judges or magistrates, but who aspire to be appointed as judges and magistrates in the near future, as well as the institution that provides ongoing judicial education to serving judges and magistrates. When this institution was conceptualized many years ago, it was envisaged that, as in a number of other countries, it should be led by a judge. But attempts to get it to be led by a judge at that time met with various challenges, which caused a considerable delay in SAJE beginning to operate. Ultimately, it was decided that it should, for the time being, be led by an administrator who would not be a judge, while attempts were made to resolve the challenges that at that stage stood in the way of the appointment of a judge as the head of the institute. Recently, the contract of the director or CEO of SAJE was due to expire, and this gave rise to the council revisiting the issue of this institute being led by a judge, because that idea had not been abandoned. What had happened was simply that the council and the leadership of the judiciary had been realistic. It had decided to be realistic in order to ensure that SAJE would start carrying out its mandate, and decided that the SAJE would in the meantime be run by an administrator. The revival of the topic of a judge as the head of the institute met with approval by members of SAJE Council recently. And an amendment to the SAJE Act was drafted by the Department of Justice and Constitutional Development, which would ensure that the institute was led by a judge, but that there would be an administrative head to be responsible for PFMA issues and other administrative matters that would not normally be appropriate to be handled by a judge. In this regard, I wish to express my and the SAJE Council's gratitude and appreciation for the determination, passion, and energy displayed by the former Deputy Minister of Justice and Constitutional Development, Mr. John Jeffrey, in pursuing the amendment to the SAJE Act to accommodate the idea that the head of the institute should be a judge. I have no doubt that the new minister and Deputy Minister of Justice and Constitutional Development will work with the SAJE Council and the judiciary in pursuing the passing of the Amendment Act to the SAJE Act. In this regard, I've noted that the new Deputy Minister, Mr. Andrew Snell, is not new to SAJE affairs, because previously he served as Deputy Minister of Justice and Constitutional Development and served on the SAJE Council. I have no doubt that his experience of some of the issues that were handled many years ago will be of great assistance to the Council as it tackles the issue of putting finality to the idea that this institute must be headed by a judge. I have no doubt that before the end of this year, or I hope at least, the amendment will be effected, will be passed. At this stage then, distinguished guests, I wish to simply say with regard to Sajay that the director who has served Sajay for about 10 years will soon be leaving. She has agreed to stay on while we look for another director, and this is the right time for me to say we are grateful to her, Dr. G, for your service over so many years. For your service for over so many years, and for your efforts in putting Sajay where it is. For over the years, it has trained so many judicial officers. I also must thank you for availing yourself to just stay until we have got your successor. But I also take this opportunity to thank the Secretary General of the Office of the Chief Justice for her support and cooperation on matters relating to Sajay as well. For Sajay and OCJ have been working together. Let me, before I conclude, take this opportunity to also thank Jade, the committee led by the Deputy Chief Justice that organized this function. Chief Justice Designate and your team, thank you very much for a job well done. But I also thank the SG and her team, the OCJ team, and there are a number of them here, for the hard work you have put into this project to make sure that today we would have a successful Judiciary Day. Thank you very much. As it was indicated by the Chief Justice Designate, that this is my last Judiciary Day, I want to take this opportunity to thank the Deputy Chief Justice, to thank all my colleagues on the Constitutional Court for their support and for their cooperation. I also want to take this opportunity to thank all the heads of court for their support, for their cooperation. I want to thank the regional court presidents for their support and cooperation, the chief magistrates, and all other judicial officers in the leadership in the lower judiciary for their support during the time that I've been here and on the judiciary days on which I've presented the annual judiciary report. I therefore officially make this annual judiciary report available to the public. Thank you very much.